Call the meeting to order. At this time, we're going to turn it over into the hands of our attorney.
Thank you, Chairman. The notice of the emergency meeting this afternoon was sent out yesterday afternoon. I just first want to thank the commissioners for making the time on short notice. With the county being closed tomorrow, typical for Fridays, and next week being Christmas, and the following week being New Year's, and the schedule of both the commissioners as well as the staff doesn't look likely we'll have an ability to have a meeting again until early January. With that, they called the notice. We received notice yesterday afternoon which warranted calling the meeting today. What I'm going to first do, the title of the public notice is Notice of Suit Pending Litigation. Yesterday afternoon, the county received formal notice of intent to file and initiate litigation against the county. In light of the holidays and the delay that we're going to have, short of individually meeting with each of the commissioners to discuss the merits of the claim and the notice that I received, by statute I'm required to call a public meeting to get authority to go into closed session later down the road. Without going through the normal steps, which I'll discuss in a couple minutes, of notifying our carrier, securing special counsel, and then upon advice and counsel, we'll call you all into a meeting, whether it be public or closed. If the merits require and the claims made require a closed session for isolated purposes allowed under statute, we'll notice that, and we've all been through the process of a court reporter, the required notice to the public of the date, and reasonable advertisement of that meeting. But the first step in that process is to require all of you to give me the authority to call that meeting, and I need to do that in a public meeting. What I want to first do is, you all have a copy of the notice in front of you that was circulated by Ms. Summers in the clerk's office yesterday afternoon. And I know I've gone through it in the past, but for the purposes of the record today, I want to go through it again, talk to you briefly about the statutory requirements for the notice for today's meeting, and then the authority to call a meeting down the road, either for settlement negotiations or strategy sessions. Statute 286 speaks specifically in subsection 11 with regards to your authority as the county commission to call those meetings and meet in private, to meet with myself or the other noticed attorneys who will be assigned to the matter. Presently, we've received a notice of the intent to file. Unfortunately, we've received a notice, but ideally we will not get to that point. Should the action proceed, the plaintiff's attorney under Statute 768 has certain requirements, as does the county. I'll begin to gather the information on the matter and meet with each of you individually to discuss it, along with the county staff, and provide our recommendations, and ideally have special counsel with regards to the labor attorney that's worked with the county in the past. Under the Statute 286, specifically, there are following conditions that must be met in order, following today's vote, if you choose to do so and provide me that authority. The first is that myself shall advise you at a public meeting that I desire to advise you all concerning the litigation, which I'm doing right now. The second is that the subject matter of the meeting be confined to the settlement negotiations or strategy sessions. The third is that the entire session shall be recorded by certified court reporter, and that the reporter shall record times of the commencement and termination of the session. All those discussions and proceedings, the names of all the people present and the people speaking would be on that court reporter, and later on that court report, once the litigation is resolved, would become public record for public record requesting all to read. The next condition would be that the entity receive reasonable public notice of the time and date of the attorney-client session, being that all members of the county receive the reasonable notice that we always post, typically on the courthouse, and if the clerk's office circulates it other ways in their normal course of business, that we send out the notice that way as well. And then the final, as I've mentioned, that the transcript shall be made part of public record upon the conclusion of the litigation. Those are the steps that are required under Statute 286. The first step, as I mentioned, which was number one, which was to call this public meeting today, explain to you the statutory requirements, let you review the notice of intent that I've received on behalf of the county, let you know the actions that will be taken following today, and then finally ask for your authority to vote amongst the commission to give me authority going forward once we have the initial investigation completed to call a closed session meeting if it warrants and the merit of the discussion fits the statutory requirements for strategy sessions or settlement negotiations. Are there any questions up to this point with regards to the requirements? I've gone through them in the past with other litigation that we've been through, and I think it's important to go through those steps each time so you all understand why we're here today. Short of the required vote in a public meeting, I could have these discussions with you each individually along with the staff, and I could answer your questions. However, this vote needs to be done in a publicly noticed meeting, and I need that authority in an open public under sunshine.
You need that now?
No, not yet. I just want to make sure none of you have any questions. Okay. Now I can move on to the content. Each of you have a copy in front of you of correspondence that the county received midday yesterday via certified mail. It is a notice of intent to initiate litigation against the county, amongst other things, for defamation, negligent training, negligent supervision, and any other civil claims available to the plaintiff against the county. The attorney is signed off as Maureen Maddox in the firm out of Tallahassee. She has been retained by Mr. James Smith with regards to this suit. She is required by statute to send this notice to the county, which I've received, and by statute I'm now required to ask for your approval going forward if it warrants to go into closed session. I provided you each a copy of the notice that we received. I don't have details or particular information since I received this yesterday afternoon. I will begin immediately to gather the information that not only they require and request in here, but also notice your insurance carrier, get special assignment. Typically, it will be our labor attorney that's worked with the county and is familiar with the county's personnel policy, rules and regulations that have been adopted and are on the books, and that firm will work with us as we move forward on this matter. I would advise the commission and the staff that if they have questions regarding this matter to direct them towards me, and I'll meet with you and answer your questions. Going forward, until I have all the information and the facts, there's really no action to be taken by this commission other than giving me the authority today to move forward. We'll follow the normal procedure of contacting our carrier and our special counsel, and I'll also ask for your vote. Is there any questions with regards to this?
Wasn't this the same attorney that the PAC group filed on just here recently in the past that we went through a lawsuit with that costed the county $15,000 to $25,000?
Yes. Ms. Maddox is the firm, Marie Maddox firm is the one that represented the recent suit against the county. What I'll need to do and ask you all now is if you'd entertain a motion after my request to give me the authority to move forward. I'll do all those things that I mentioned, the actions and the steps. The only thing I need the authority from the commission at this point is to go and call and advertise a closed session meeting.
So moved, Mr. Chair.
By Mr. Yeager,
Second his motion.
second by Mr. Mike Daniels. Do I have any opposed? Do I have any opposed? No opposed, motion carries
Okay.
5-0.
Mr. Chairman, I thank the commission for that authority. Again, the only other comment I have is please, if you all would, I've mentioned it before, again, if you have questions pertaining to this, please direct them to myself, and we can set up the appropriate meetings individually. Answer your questions. I'm sure when council comes down, if you have, I will notify you all so you have the ability to meet with our labor attorney as well. As we get into the merits of the case and the facts, I will share them with you in confidence, one-on-one with staff and with our special counsel, and we can move forward accordingly. And again, I thank you all for your time today.
So moved, Judge? Oh, wait. Did you have something else?
Yes, I do. I'd like to address Mr. Hammond over there. Have you looked at this? Ms. Hammond, can you comment on this?
Not getting into the merits, I'll give you the background, as I have previously said in previous meetings, and without getting into before the attorney stopped me, without getting into the details of the case. This is one of the citizens that Commissioner Bryan's been talking with. This is an individual that separated employment more than 3 years ago. After talking with Commissioner Bryan, he brags that she's going to get him back, she's going to get his back pay, she's going to get my job, and they hired the PAC's attorney and filed a lawsuit against us. So that's basically the background. This was a jail employee.
That is absolutely not
I'd like
true,
to do-
Mr. Hammond.
Mr. Chairman.
You didn't meet with
Mr. Chairman.
You need
Did
to
you not
mind
meet with him?
yourself.
Did you not meet with him?
Mr. Chairman.
Hammond,
Hold on,
that is not true.
What I-
Mr.
what-
Chairman, this is
I'm gonna let you speak.
absolutely
I'm gonna
not
let you
true.
speak. Okay, it's your turn to speak. Go ahead on. I just want one at a time. I don't want everybody speaking at the same time.
Okay, again, if the staff and the commission can direct their comments to me as counsel, and we can have private discussions regarding these matters, I think that's, I've said it in the past, it is the appropriate form in which we all have these discussions and conversations between staff and commission. This is not the place, nor to get into details regarding this matter. I'm not familiar with it, Mr. Chairman, and I'd like to get my hands around it and also discuss it with private counsel, but these discussions between county staff and county commission need to be done one-on-one. If we need action of the commission, we'll do it in a meeting, in sunshine, and at the podium. But
All right,
short
so
of that.
now, what I'm asking the board to do is let's go with the recommendations of our attorney.
So move to adjourn, Mr. Chairman.
Well, before you adjourn, I just want to make a, not related to this case statement, but just a blanket statement that Mr. Hammond has repeatedly stated things about me as a county commissioner that are absolutely not true. I agree with Mr. Novak that it's inappropriate. And I would like to state for the record that this information is false. And I would be happy to talk with you outside of this meeting room, but I'm going to ask you today to check yourself and to stop this behavior. And it's clear, I think it's clear to the public and the viewing audience that this was very nicely teed up by the commissioner next to me for Mr. Hammond to take a shot at me. You're not fooling anyone, and it's inappropriate, and the people of Gulf County deserve better.
Mr. Chairman, I will keep it to a minimum. The problem that I have with Commissioner Bryan is speaking with former employees and disgruntled jail inmates' parents. They are coming back to me and saying they're talking to Commissioner Bryan, and the public is talking about it. It is a liability for a county commissioner to go outside the county administrator, the county attorney, the human resources director, with fired employees or employees that quit under duress, and be discussing them. And it's just amazing that after they speak with the commissioner, her citizens, that she says, that they hire the Pikes attorney to sue us. Now, we're going to win this claim, and there are more. I mean, it's not the only one that she's talking to. But it is a problem for staff when not one time in the 13 and a half months she's been commissioner has she been to the county jail. Not one time has she asked about this individual or the other individuals that she's talking about. We're not talking about information that the county staff can give a commissioner. We're talking about her meeting outside the bounds of the county and then us getting sued.
I will continue to speak to people in our community,
Okay,
and you know, Mr.
We'll continue to get...
Smiley, that's our job.
I said, but I want to go with the recommendations of our attorney. He said, you know, we speak with him in private. I got a motion by Mr. Yeager. I got a second by Mr. Mike Daniels.